Yeah. So whenever we start for any NCA preparation, first I ask the students to read the syllabus, specifically this part. Okay, objective of the course. That gives us a slight hint to what they are looking for,
Okay.
what they want you to know. So here we get the idea that they want you to understand the, basically overview of Canada's legal system and the role of the law in Canadian society. So we are
Yeah.
all the NCA candidates have come from different countries, different law background. But what does the Canadian law is? What is it, and how it impacts the daily life of the people? And
Yeah.
here, because lot of theories and theoretical approaches we are seeing, it's all goes back to thinking, right? So thinking. So that's what I was saying in the yesterday's consultation call as well. That it makes you think, okay, and review various legal theories and particular areas, specifically with respect to core sources of the Canadian law.
Yeah.
Then different branches of government, not that important from the exam point of view, the chapters with respect to legislature, executive, and all those things. But you just have to understand enough to compare the different branches.
Yeah.
Okay. We have not seen many questions coming from those chapters, but we should know what it is. And of course, we'll have the notes handy. It's an open book exam, so we can figure it out if the question comes from there. There is not
Yeah.
much thinking there. It is like 1 + 1 = 2 only. There is no question about, okay, executive is having these many, components. That is it. There won't be more than that. Only the other chapters that makes you, gives room for thinking and putting your opinion. Then, of
Yeah.
course, Aboriginal, that chapter 2 is very important. And especially this part is also very important. That is with respect to treaty making process, okay, Canadian treaty making process, and the implementation of international law into domestic law. This one is
Yeah.
very important. They've been asking, questions, at least one question on this, at least in one paper out of 4 days. Okay.
Okay.
So you might get it, but somebody else might get it. But there is going to be a question on this part as well, either
Okay.
on the treaty making process. That's again, like the process is fixed, right? There is not much thinking over there, so that will be an easy one. But about the implementation of international law into domestic law, there they might have some, some play, like they might play with the facts with respect to, how it impacts the domestic law. There is an international law upheld by, UN, or like decided by the UN, and Canada is a signatory.
Hmm.
Now, how do they, make it into domestic law? Or do they have to? And somebody is, basically Mr. A is there. He is coming to this mm, municipality, okay,
Yeah.
municipal council, and he has a grievance basically.
Hmm.
So he says that according to the international law, he should have been given this particular license, or he should have been approved for this particular thing, but
Hmm.
there is no domestic law. So the municipal, the whoever the person is there, a decision maker basically. So he says that there is no domestic law that I have to follow. I am
Yeah.
actually obliged to provincial law. More than
Yeah.
that, federal law. There is nothing that is, in my authority that I can rely on a particular domestic law. So then this
Yeah.
Mr. A says that there is an international law, and it is the duty of the Canadian legislatures. Who makes the law? Who implements the law? Legislature. So it is the duty of the legislatures to incorporate that international law because you're a signatory. So there is
Yeah.
also, I think, an article and a case law on that. So we'll come to that. But this is a very important,
Okay.
part.
There
Other
is
than
one
the
question about this in the sample exam also.
Yeah, yeah. So this is very important. Like from sample is very old, right? So since then till
Yes.
now also it's important. The other, sample questions or other parts are not that important. But like I said, the skill coordination versus British Columbia, that hint also I got from sample exam, because in sample exam there were a lot of case laws that they had given, right? One question.
Right.
Yeah, so that question was like about, I think, tort or contract. Yeah, contract, some doctrine of contract. And they had mentioned don't go into the contract law.
Mhm.
You are supposed to only answer it with the syllabus of foundations of Canadian law. So how do we see that? So there are a lot of case law. Definitely, it comes about it connects to precedent concept,
Mhm.
and whether it connects to any other thing, that also we will see. But that's why this one is important, and from different angle they can ask this, and they
Yes.
can make a fact pattern, they can make a theoretical question. So this is something important that sometimes we lose sight of, because mostly we give importance to chapter 2, chapter 9 and 10. So this is something to point out. Then we have Aboriginal people, of course. Chapter 2 entirely it is important. Why it is important? We have to understand the special relationship between the Aboriginal people with the Canadian state, and to critically assess the impact of the Canadian legal system upon the Aboriginal and other minority communities. So this part is very important. They want you to critically assess. They want you to be able to critically assess after understanding who are the Aboriginal people, where did
Mhm.
they come from? They are the original people of Canada. They were the natives, right?
Yeah.
So now after the colonization, after the laws and all came into picture, so how it developed, that you should know one thing. Then the current system. So this foundations of Canadian law syllabus focuses on the current situation. Okay, and
Oh,
they mainly talk about, they'll give a situation where an Aboriginal community or a Aboriginal person, okay, indigenous person, he has a claim. Okay, where does he go? And how difficult it is for that person or that community to get that particular right. It could be Aboriginal right, it could be Aboriginal title or treaty right, or it could be about their self-governance as well. Self-government is one of the important topic which is not there in your constitutional law subject. Other
mhm.
things you have, connection from constitutional law, but this self-government is something that is different, right? We know the
Mhm.
core concept of it, but how the questions will come, we'll see when the syllabus is in front of us. To provide applicants with an understanding of the nature and function of judicial review and the basic approaches to the statutory interpretation. This is important, and also judicial review. Now, you have done your administrative law, right? So
Yeah.
usually, when a student comes for foundations, and I say that, have you written administrative law? If they have not, I ask them to first study what is judicial review, because then only this particular concept will be more clear, right?
Right.
So judicial review. What is judicial review? We have seen procedural fairness, substantive fairness. So basically these two things, right? So how
Right.
many types of judicial review are there? How it is done? And why it is good or bad? Basically, that is what we are thinking. We are not at all bothered about just the process. We are bothered about the thought process behind the process and the impact of it, the real life impacts. Earlier syllabus, there was article on bakers, rethinking baker by Alicia
Mhm.
something author. That is not there now, but they had put it in the first chapter. That's why I'm telling you, they had put it in the first chapter here. Now here
Okay.
there is a Asha Kaushal article, right?
Mm.
Sorry. So they had put it for critical feminist perspective on law. Okay,
Okay.
feminist perspective on law, this concept and that article connected. Plus, that article can connect to this particular chapter also for the judicial review under the chapter 10. So
Okay.
whenever, yeah, so that's what I wanted to connect, is that judicial review can also connect to one of these theories. So which
Mhm.
theory makes more sense, you can connect. Okay,
Okay. Okay.
yeah. So yeah, this one, like, just go through again, and if you are not able to make that, if you're not able to reach these objectives by the end of
Mhm.
your preparation, then you have to revise that particular concept. If you are
Okay.
not able to, understand the basic approaches to statutory interpretation, then go to that chapter and revise it. So this is how
Okay.
I prepared for my exam as well, and this really helped because there is no hard and fast rule for this particular subject, right? So we have to like read a lot, we have to analyze a lot, and this is the only thing that the directly from NCA that we have, which gives us some hint to what we should be prepared for.
Okay.
Okay. Coming to statutory interpretation also, there will be something, some law or some section of a particular statute given there, and somebody will be saying that like the court is interpreting it in such a way, and the applicant is, arguing that it should not be interpreted in that way. Instead, it
Mm.
should be interpreted in a other pattern. Now,
Yes.
that situation gives you, they will not write these words. Statutory interpretation word will not be there in your question. Okay, so there will be a law, but they're interpreting it. They'll say the meaning of this, or this could be analyzed as some other synonyms will be there.
Mm.
Okay, so there is a law, there is that is being extracted for a particular case or for a situation. So by the court, and it could be also at the time when legislatures are submitting their drafts, right? So there goes
Mm.
one round of interpretation as well before it is enacted in the first round, second round, like that, and all they do, right?
Okay.
So
Yeah.
yeah, so it could be that situation or it could be a case law situation as well. So it could be both, but there'll be a term that they are confused about or they are not
Mm.
on the same page about.
Like one
That,
party, the court is analyzing in a certain way, and the aggrieved party will say it should be, interpreted in a different way, but they won't use those exact words.
yes, yes. Interpreted could be there, could not be there, some synonym would be there. Okay. So, but basically they are not on the same page about one word's meaning or one case, one section's, entire section's meaning. So that
Mm.
time you will connect this with the chapter 9, I think, statutory
Yeah.
interpretation. Yeah. So then you will write about there are different ways of statutory interpretation. First, you have to recognize, right, the topic. What is the topic? So in the introduction, basically you're connecting the question to the syllabus. That is the
Right.
bridging part, right? The first paragraph, you have to put a good impression to the evaluator that you know your stuff. Okay.
Would
So
it be
in
necessary or would it be helpful if in the beginning of the answer we write like explicitly that this is connected to this topic or something?
Yeah, but will not straight away say that. It may look, I mean, it's not wrong, but my suggestion is that you have to write it in a full, like 3 sentences, right?
Yeah, yeah.
Make 3 sentences how you will introduce a concept. Think that this particular chapter, this particular subject, basically, you have to think like you're a professor. For all other subject, I say that you have to think like you're a lawyer. You are in the courtroom. You are arguing before the judge. So accordingly,
Mm.
you write as if you're talking to a judge. We will not say, my lord, this particular topic is from so and so, right? But
Yeah.
in the classroom, how would you teach? You will introduce the concept first by saying, this particular case law connects to statutory interpretation, but
Mm.
you will have to say it in a little bit, sugar coated words.
Yeah,
You
not so
say,
explicit.
yeah, not so direct, but still, after reading the 3 lines, the person should know that you're talking about statutory interpretation. So the
Mm-hmm.
end of that paragraph should be this connects with the chapter of statutory interpretation. Don't write chapter, concept of statutory interpretation. But starting, I would say, like, whenever there is a ambiguity or there is a confusion of the meaning of certain term in a legislation or in a law, right? It has to be interpreted as per the set principles of the law. This is
Mm-hmm.
something general, right? This is a general sentence. I just made it up, right? But that gives us next, opportunity to write a next sentence directly about statutory interpretation.
Mm-hmm.
Next, you can write, therefore, or you can write, um, the principles of interpretation, set principles under the law, right? That's what I wrote. Then I will write that in order to interpret in Canadian law, right? First we wrote general, then we are
Yeah.
specifically coming to Canada, then we will come to foundations. Okay, so then we'll say in Canada, in order to interpret an ambiguity term, ambiguous term, there is a concept of statutory interpretation, which has different approaches, right? Then
Right.
there you stop. Approaches and all you don't have to explain in the introduction. Different approaches are there. Like it's some brief you have to just connect.
Mhm.
And then
Right.
by reading that 3 lines, don't write more than 4 lines under introduction. Okay, 3 to 4 lines is max. Then you come to the main topic. Now you know main topic is statutory interpretation. So your body of the essay should have a side heading that is statutory interpretation. Okay, so that's why the second, yeah, introduction हो गया. Then उसके बाद you have the topic heading. Topic heading is statutory interpretation or different approaches to statutory interpretation. That is up to you. You can write any side heading that makes you feel like, okay, this is a good presentation of my answer. So you choose a
Mhm.
good side heading. Then you say that how many different approaches are there in the statutory interpretation. Then you go on by connecting. So whenever you write any NCA exam, you have to know that they're not looking for only a theory answer. They are looking for application,
Mhm.
right? In every feedback, we see that application is low. So we need to give them this, I call sandwich method, okay? So you write one general sentence, you connect it with the law. Next sentence is next layer of the, sandwich is the facts. Okay. So then conclude it with the law, like mixture you have to do. So this layer, when you write and then you conclude, that makes a perfect sandwich. And it gives
Can
them
you
an understanding. Yeah.
repeat this sandwich thing again?
Yeah.
The steps.
So first layer is about the law, the general thing, right?
A
Anything
general statement about the law.
general statement about the law. Then
Hmm.
second layer is the actual specific law.
Actual specific law. Okay.
Then third layer is the facts. You
The
will take
facts
out
and the
the,
proofs.
yeah, you will take out the sentence from the facts or a particular para or sentence, whatever is relevant for this particular answer, no? That only, because there will be unnecessary things also in the facts. So you'll just take the relevant lines of the facts and you'll rewrite it, okay? But not in the exact same way, like if they have written um, um, introduction to an overview of Canada, like this, something I'm just giving an
Hmm.
example. If these are the words, exact words, you'll make it in, like activized to passive voice, basically, simple as that. So just make sure that you're writing, and if there is no time, write as it is. Okay, just write as it is. So the relevant para of the or the sentence of the facts you'll write. Then the next layer, the last layer, is the application of the law to the facts. So
Applying the law to the facts.
yes, yes. So this all comes under your analysis part under IRAC. This is how you might have written in your other exams also. But knowingly or unknowingly, some arrangement will be upper niche. That's all. You might have written this, but
Is
in your
this basically like coming in, like, so you know how a general formula is like you do the introduction, then you make like a bit of a thesis statement, then you do your critical analysis. So this, all these four statement, points will
layers,
come under
yeah,
the analysis, right? Like you reiterate the law again, then you talk about the specific, the statute or whatever, then you state the
yeah,
facts again and apply the law to the facts.
yeah. So one difference between the IRAC of any other subject and foundation essay is that there you will do the analysis only under analysis section or application section.
Mm-hmm.
Here, you have to do it throughout. Your essay has to, you take a thesis and drag it and like, take it different routes and then come to a conclusion which you started with, right? So that is how your essay works. Essay that we write for, blogs or, any article that we write, it should not be detached any part of the essay. If I read like a third page, fourth paragraph, it should still connect with the main topic. It should not be something generic.
So
Okay.
it shouldn't be like there's only one part of the answer with the analysis. The analysis should be throughout.
Yes, exactly.
And
So you have to keep.
when you say analysis, it's mainly referring to the step 4, right? Which is application of the law to the facts.
No, all four layers. So that's why I said it is a mixture here. So that's why you, when you go by layer, and again you will come to the second sandwich. So first sandwich is like in one particular paragraph is like one paragraph of your topic part. And the
Hmm.
second part I'm talking about, no, the body of your essay. It will be side heading of statutory interpretation. Then you will talk about there are two different approaches. Now, which approach is exactly needed for this particular facts of the case? So for that, you will use. So first, you wrote about what is statutory interpretation, the meaning. Then the specific. So that became the generic line, first layer. Second, approaches to interpretation. Two approaches
Hmm.
are there: modern and what was the other one? Plain meaning? No.
Plain meaning and doctrine of infidelity to legislative intent. And
Yeah. Just a second. There is exact word for it. Modern approaches to interpretation, because this is the one required. The second one is, yeah, basically under this particular paragraph of your notes, there will be two different types of interpretation,
hmm.
right? So that you will mention. Okay, there are two types of statutory interpretation. And now currently, which one is applicable? Modern approach only. The law, case laws and all
Text
are
context
approaching.
and text
Huh.
context.
Yes. So only the modern approach is to be applied in the current scenario. So that is
Hmm.
the specific thing. Okay. Then you have to now write about the facts. So in this particular case law or in this particular facts, they are talking about this word or this particular statement, which is interpreted by the court as this and by the opposite party as this. So you have taken the exact part of the question in that particular layer of the sandwich. Then, because the last layer where you're directly answering the
Applying the
application,
law.
yes, applying the law to this one. So you're applying, and how would you say that is your direct answer, right? So you apply a theorem and then you come to whatever conclusion. That is your application part, nothing else. Hmm? So you're saying that applying the current Canadian law on this particular interpretation of this particular clause or term, it has to be modern approach. It has to be modern approaches to interpretation. Why we have to now you have to connect it with the syllabus material. Why you are saying that modern approach is the best or modern approach is the one you have to apply? Students stop there. Okay, modern approach is the one, and they will write theory about what is modern approach, how it is done, blah blah blah. That is not required. You have to connect now why. So in order to answer why, any lawyer makes up his argument uh, with the support of first point law, second point case law, third articles, or any
Hmm.
secondary resources, any textbook or any recognized book, right? So that is secondary resource. So these three things you need to have. Then the fourth one is your opinion. Now, these four things you have to write in the next paragraph. Why did you say modern approach is the best interpretation or is the correct answer for your question?
Hmm.
Okay, so that why you will explain with the help of these articles, case laws, or whichever applies to your modern approach from your syllabus. So that's why you have to keep the printout of this particular syllabus, and it helps us very much because the notes will be, I don't know how many pages are your notes, 100, 200,
Yeah,
right?
yeah.
Yeah, it will be difficult to follow through. So
Hmm.
and like I said yesterday also, your foundation exam is more about what you understand and what you have, what is your opinion, how you would do it. So notes is not going to help you as much, and none
Hmm.
of the printed material, it's not going to help as much as your brain. So we just need this particular syllabus copy and a deeper understanding of the concepts. With those two, you can nail the exam. Okay.
But I
So
have a question.
yeah.
So, you know how you said that a lot of the feedback on like the exams is
Hmm.
that there's not enough analysis. So,
Hmm.
when they say not enough analysis, I know you said all the four layers of the sandwich count under analysis, but do you think specifically when they say like a student has not analyzed enough or there's not enough critical analysis, do you think they're talking more about the law and the facts and not really using the fourth point, which is applying? Because I think that's the hardest of all, right? Because it's very easy to say that this is the law and there's
Yeah.
these are the four, the golden rule, the mischief rule, and all that. You state the different approaches and then you state the
Yeah.
facts, but like how you said that why the modern approach applies. So I
Yes.
think when
The
they
why
say
is missing. Yeah. Well, the
the
why and
analysis,
explanation to why is missing. Yeah.
exactly, so when they say the analysis is weak or less or poor, I think it's the fourth part which is the not, like, shelled out enough, right? The application
Yes.
of the law to the facts.
Yeah. So basically, they're looking for is whether you have understood the concept and you're able to solve a situation based on your understanding. That only we can say. Now you come up with a doubt. You go to your professor. You ask a concept doubt, right?
Mm.
And they say that, this used to happen in our school as well. Like, I go to a math professor and I used to ask a question, and he's like, "Okay, this is how it is, right?
Mm.
1 + 1 is equal to 2. That's how it is." And
Yeah.
all these Pythagoras or whatever theorem, usual theorems. And I
Right.
used to not understand. I was a bright student in all other subjects, and I was not getting good marks in maths. And my mom sort of grilled my teacher as well at one point.
Mm.
Then, like, my mom raised that question, in the parent teacher meeting, that you're telling what is there in the textbook, but maths is to be understood. My professor was doing, this is how it is, you have to buy it or whatever. He was
Yeah,
also
yeah.
brilliant, but he was not doing that methodology. But he changed after midterm. The professor's nature only changed, and he started saying why
The
it
why.
has to be like that. So that is what missing in most of our answers. When NCA says that your application is not enough, you have to give reasons. So look, whenever anybody explains your concept, saying that why, two people break up, just break up, done. You have to get the closure only when you understand why.
Mm.
Correct.
Right.
So yeah, so like that, you just have to be a little bit, philosophical here, but at the same time, you have to be explaining why you have chosen this particular answer. So your explanation to it, you're convincing them, right? Try to convince them in the next paragraph. Right after that, application line where you said that yes, modern approach is the one that applies over here. The next paragraph you have to say about why, by taking, as Mark Mancini said in this particular article of two uses of purpose in statutory interpretation. He said something, right?
Right.
If it is useful to you, then take that paragraph where author's perspective. So what I do, I'll just show you quickly. So let's say this is the article, right? So for each article, I give a summary for students so that there is an introduction paragraph if they have, direct questions from the article as well, and the parts of which what we learn. Question. Okay, huh.
Mm-hmm.
This is the part which will help you to understand what exactly is told in this particular, author by this author. And certain case laws also they have mentioned. Let me show you a particular concepts.
These are the actual notes that you give?
Yeah, yeah. So this is the additional, updated syllabus. So this was the updated one where there is an author's perspective. No, so I've given the paragraph with author's perspective. So, for example, now we have. hmm, I think I'll show you the main notes.
Or versus or? Oh, sorry. I thought it's
So here in the paragraphs, one paragraph, no, now this was the new article closing the implementation gap. Like I think this is the one yesterday we were talking about,
yeah,
the
yeah.
gap, right? So there is one author's opinion, right? Hundreds of pages of articles are there, like 80 to 80 plus pages will be there in some of the articles, and it is difficult to sometimes pinpoint. So this is one paragraph which helps students to basically take the paragraph and just read this four lines. It is so
Exactly.
easy. Yeah. So just read these four lines, five lines, and then connect that with your answer, where
Mm,
you have to say that as the author said in this article, like this, it was his stance. What was his stance? And then
mm,
the next one is this article. This article is also connecting with the interpretation. Then what happened in this case? And also this particular interpretation happened in this way in the telecommunication case, and it is a recent case, so you
mm.
have to write it and then come to your opinion. So, in my opinion, underline that part. In my opinion, is there no? That you have to underline that word so that they
So,
know that you have put your opinion as well.
so I would say, from what you're saying, the application to the law to the facts is usually less, which I am sure mine is less. That's why I didn't get a good grade. And
Mm.
the why, that's the why, which is very important. That's the main
Mm.
part of the analysis. So in that, when you apply the law to the facts, I would apply the statute law, the case law, the articles, all of that to the facts, a mixture of everything. And in the end, say, after analyzing all these scholarly opinions, my opinion is this, right?
Yeah. So, in your opinion, you will write a paragraph, then the final conclusion. Conclusion can be, basically in your support of your opinion, whatever you stance you have taken about, right? That's how essay works. You start with a theorem, you prove that theorem.
Right.
Yeah, so the conclusion has to be direct answer to whatever question they have asked. So basically, whatever they have asked, your direct answer will be in the conclusion. Direct, no beating around the bushes in the conclusion. It has to be again like an
Right.
introduction only, 3 to 4 lines, but it is the direct answer. So if I have to, review anybody's answer, first I look at the conclusion. And if
Right.
I have to analyze any question, because sometimes students have, I have only given like 2 pages of question, right? So one question is like so long. How will I know that which concept it is from? I give this tip to students also. So the last paragraph, look at this last paragraph. It will give you a hint. What is the topic from? But that does not work well with the foundations exam. Okay. So uh, I look at the last paragraph and understand that okay, this is from Aboriginal or whatever concept, and then I look at okay, what they are asking is right there, and then I look at the conclusion. If that those two doesn't match, then I look at the analysis part. Nobody looks at the issues, rules, and all because they are ready made. It's there in the IRACS, right?
Hmm.
In the practice questions which my students send. So analysis is where your more marks are there in the other exam. But here it's not like that. Here it is throughout. It is spread across throughout. So your body of the essay, that topic or whatever subheading you use, no two articles or no two essays are similar, right? That's why we call introduction, body, and conclusion. Middle part, the body can have 5 subheading, 3 subheading, whatever. But it depends on the marks also, right? You have 20 marks question, you write 400 words, not more than that. Because accordingly, you have to manage your time as well. So while you're writing, your thinking has to be on point where, okay, what I'm going to write, just think about it. Make a plan, like, mapping in your brain that okay, this is how I'm going to start, this is how it's going to look in my body of the essay, and this is going to be my conclusion. And before starting to write, just refer whatever material you need to make that mapping concluded, right? Confirmed. So I will see that, okay, I have a doubt whether this author supported this statement or against or criticized this statement or this law. So I will just check that part in my essay. Exam day assistance I have prepared, I told you, no? So this one helps for that reason.
What is this exam day assistance? Acha, this one which you gave me.
This one. So, supporting cases from the syllabus, supporting articles from the syllabus. For this particular topic, this is from the first chapter, positivism. There is no article. So, I would have a clear understanding, and one your opinion statement also I have given. Of course, the students have to change it because if everyone write whatever is here, it will be difficult.
This
So,
is for this thing that you've prepared is for every topic.
yes, so you can see natural law, and there are 66 pages which contains all the topics. So even everything in the syllabus basically, okay? So it contains everything. Only the change that you have to do is the syllabus of foundation is changing every time, right? So only the article you have to update here. Some articles
In
over here
this is with
is
the old articles, yeah.
yeah. So that is the reason why I didn't try to, sell you this because it'll be bad
But I
because
actually feel this is helpful. Like I feel I should get it
for
because
the other part it is helpful. For
I
example, the
mean to say
concept.
that if there is some outdated article, I'll automatically understand because I know which all are there in the current syllabus.
Yes,
So I
yes.
won't use it because I know exactly which articles are there.
Hmm.
But for the other parts, I think it's quite helpful.
Yeah.
Yeah.
So the your opinion part for any concept that these paragraphs are very useful. You just have to paraphrase it in your own words.
This
But
document is how many pages?
this is 66 pages.
And this full document is that template for every topic, right? That's what you're doing.
Every topic, yeah.
Okay.
Every topic. Basically, how we give IRAC for other subjects, no? This one is, prepared by me exclusively for foundation. For the, everybody asks for IRAC, but for foundation, we can't make IRAC. So I came up with this idea, which helped a lot of students to pass. So I thought this will be helpful, but I've been, I'm waiting till they update the syllabus in 2026 so that finally one update I can make. But seems like for January they have not updated, so I can update this as well.
That's
Maybe for the
okay.
next, yeah.
But so what I just wanted to ask you, what I forgot what I wanted to ask you. Oh God. What was my question? Should I had some question which I totally forgot. What did I want to say?
So
Okay, you
basically,
talk. I'll try to remember. I forgot what I
yeah,
wanted to
yeah.
say.
You can interrupt me when you remember. So basically, this is a combination of my notes, okay, and the question and answers, like whatever questions I have seen, whatever article is there, everything, like the notes, the articles, and question and answers, structure. So everything is mixed up in one notes. That's why I call it exam day assistance notes. So I can't call it IRAC. So I called it that so that everything is right here and. The thing that currently you have to do is because it's not updated for the case law and the articles, so you have to keep your syllabus in hand whenever you're referring anything from here. Just cross-reference with the articles or case law that is there here, and you can see from the notes also whatever is updated. So that's
This
what like
old syllabus, is there a lot of difference? It's just few articles and cases that are different, right?
articles and cases. Yeah, that's it. The concepts,
No, but
everything is same.
no, concepts I know is same, but articles and cases, how many roughly are different? Like,
Mm, the articles last time they changed around five, I think, 3 to 5 articles maximum.
and 3 to 5 cases also, no?
Yeah, yeah, yeah. Yeah.
Oh
I
yeah,
think I have that
I
comparison
remembered what
notes.
I wanted to ask you.
Yeah.
So firstly, I wanted to ask you is that, how you're saying that in foundations you have to do the analysis throughout.
Mm-hmm.
But then they throughout I understood what you are trying to say, but it has to mainly like you have to still do it only in the body of your answer, right? You're not going to be doing analysis in the introduction and conclusion, like as you said. So in the body, you mean it has to be throughout.
Yes. But the connection will be like, in the introduction, you're stating that this is the concept. So that's where it starts, and in the conclusion, it ends. So it's there. The essence is there in the introduction and this one, but the reasons and everything, the explanation comes in your body of the answer.
Okay, and actually, I had another question also. Can you give me a rough idea of how many words I should write for the marks?
Yeah,
Because I
I'll give an
feel like
easy.
sometimes I make a mistake in that because suppose say it's 20 marks, but I know
Hmm.
more about the topic, I might just write more, which is not use of you any
Hmm.
use.
Hmm. Yeah. I'll give an
So like
easy
yeah.
this one formula. Whatever the marks is, double it and add a zero. That many words you have to write. 10 marks,
Oh,
double it, 20. Add a zero, 200 words. That's how much you should write.
oh, okay, okay, okay.
Yeah,
And
this
what are the
actually, yeah, this is a formula given by one of my student. I told you know the one who takes all the one-on-one classes. So he figured it out and he started applying this formula. And even I saw, okay, in 200 words, yes, we can actually make sense with the entire 10 marks, whatever is needed. 200 words are more than enough to make the answer.
so do you know what's the which is the highest mark in a question that they give? Like how what's the biggest question like with how many
Which
marks you
topic? Yeah, which topic
No, no, not
is
which topic. I mean to say, like, what is the question with, like, what's the
more
highest
marks?
mark?
Okay, okay, okay.
Like, will
So.
they give anything more than 30 marks or something like that? I mean,
See, NCA has been always secretive about that, like how their marking system, right? But what we have experienced, like, of course, in the next term it might change, but till now, what has been happening, that I can tell you. So they give either six questions, 20 marks each.
Mhm.
Okay, that's the basic. Like less than 20 marks, I
Five
have
questions.
not seen. Yeah, yeah. Yeah, yeah. Five questions, 20 marks, or even I got like five questions for 20 marks. And or they may give like one question for 30 marks and rest for 20, like that.
And then there's also that thing where some people have got a short answer question of 10 marks, I've heard.
Yeah, so that could be like a comment on a paragraph, uh, on a author's articles, whatever author's perspective is there, that paragraph they'll give, and they'll say that what do you think about it? What is your opinion? Do you think it is true what the author is saying? Like that, it's basically like a short answer question, right? Ten marks. So it could be a comment on a case law, comment on this, like that. They might give that, like in constitutional law also, they give that 10 marks question. So similar
And
pattern.
you think it's rare for them to give like a 40-mark question or something, 40, 45 marks. Like that's rare, right? They
Yeah,
could give
yeah,
anything could happen, but I
yeah.
think the highest usually is about 30 marks.
30, yeah, yeah. 30, maximum 35 we can go, but
And so
not more than that.
you're agreeing with this formula. You think it's correct, right? Like say if it's 30, then 600 words.
Yeah, yeah, yeah. I'm agreeing with
Matlab
that.
up and down, like roughly it could be
Yeah,
650,
yeah,
but roughly
yeah.
you think this formula is correct.
Yeah, yeah. So that's why when you stick to this, introduction 3 to 4 lines, not more than that, then in the conclusion 3 to 4 lines, then you know exactly how many words are going there when you're doing practice answers, right? And then the body, okay, this many words I have to fit in here. So that's where I told, do the mind mapping. So when you map your answers, like, okay, this is how I'm going to start, this is how I'm going to end. So it takes 2 minutes. And that's the best 2 minutes you can use during the exam, per question. So just think about it, cross verify with your material, and then start writing. So what students do is they just, sometimes they look at the notes and start typing, okay, introduction theory. They just end up writing entire theory and waste time in typing unnecessary things.
Right, right. I think very big problem with foundations, which I'm sure I made and people make, is that there's too much of reliance on theory and less on the why, the
Yeah,
application, the
yeah, that is. So now quickly we'll do a revision. Like so far, I was just trying to tell you the overview of how the
That's
questions would
fine. This is
come from.
helpful. This is helpful. So don't, it's
Yeah,
good.
yeah. So now let's just go with the direct. Like I'll question you. You just tell me in your own words. You can refer your materials, of course.
Okay.
Take a minute and you can answer me what
Okay.
that concept is. And would you like me to go with the chapter wise or randomly?
Up to you. Random is also fine. Doesn't matter.
Okay. So, what is the concept of feminist perspective on law? What is the meaning of it?
So feminist perspectives on law, it is a it's another theory of law which talks about how feminism and gender inequality is like the law is a way to continue that existing structure of gender inequality. So just like critical legal studies which talks about how the law is a tool to use like suppress disadvantaged people, in feminist perspectives you talk about how the law is used to keep one gender kind of at a
Hmm.
disadvantage, but then also the new theories and scholars use the law itself to create equality. And just like in critical legal studies they say the same law which has disadvantaged a group can be used to create advantages and create opportunities and bring equality.
Okay. So one mistake you did was I asked about feminist perspective, you connected with the, for the
Yeah, yeah,
comparison. Yes.
yeah.
So when a question, of course, the question if that is asking certain comparison between two theories, then only talk about another theory. Otherwise, stick
Hmm.
to that theory only. Now,
Okay,
how
okay.
you would have improved your answer is that you told correctly that feminist perspective on law, how the law used to be like it was disadvantageous for women, but give example how it was. You just stated general statement, right? Now, can
Yeah,
you
yeah.
give me an example of the past? Because currently the situation is different, right? Do you agree the situation is slightly better than before?
Yeah, 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 definitely, definitely.
Definitely better,
So
right?
I
Because
just wanted to say one thing is that we don't really in the required readings we don't have any article or cases about
you don't need
feminism.
articles or cases. I mean, earlier cases are there in your notes. You're supposed to have, let me show you, chapter
Because
1,
most
right?
of the article required readings on race.
Yeah. So not every time. That's why I asked you this question without any feminist. Okay, let me go to. In notes, what I did was I kept the last one, updated material. Oh, sorry. Yeah. So the first chapter I did it at the end because it was slightly boring. So I started with the sources of Canadian law while teaching as well. So feminist perspective on law in your notes you're supposed to have these cases. I'm sure you might have read about it. So there was this Women's Suffrage Act in the year 1918,
Mm-hmm.
okay, which gave every female British subject over 21 the right to vote. So this is where the turning point happened. Before 1916, women were not allowed to vote at all. So this is what you're saying about feminist perspective on law is coming from this angle that earlier there why was the need for this feminism, because there was inequality, right? Feminism is not about putting women ahead. We know that. So it is about equality. We are just fighting for equality. So where was the inequality? You have to give reasons, right? So prior to 1916, there was, no way that women could vote. So the change happened in 1918 with this particular act. Where women above the age of 21 were given the right to vote. Then there was this situation
Morgan. Yeah, Morgan
where
Tell.
yeah, Morgan Taylor was there when women's right to abortion was also not their choice. So that those things, and there was one more thing, qualified
There's
person. So
also there's also the thing about where I think in the I don't remember the date in which decade, but in the 90s they said that for the Senate women
yeah,
are
this
person.
one. Yeah.
Yeah,
So qualified person. So Section 24 of the British North America Act of 1867, which is now called as Constitution Act of 1867.
yeah.
So that stated that only qualified persons. So persons did not the interpretation. You can connect it with the interpretation
Yeah,
also.
they
So
earlier thought
yeah,
of it as men.
men, exactly. So this is, this one you have to connect with the, early formalist
Yeah,
feminism, all these things from your notes. So just try to, point it out over there. And then Morgan Teller case
but
was
I
there.
have one question which I'm confused about,
Yeah.
right? Like now the notes, see, like everybody which who gives the notes has some differences in the notes.
Hmm.
So like some small cases, like maybe in your notes you have these, in some other notes some cases are not there. But what is the meaning of the required articles versus the no cases in these? Like why are those required and these, like I just don't understand why certain articles are under required and certain cases while others are just within the notes. Like I don't understand
Hmm.
this distinction.
Yeah. So basically, in the syllabus, if you see, there are prescribed book, right? So
Yeah,
each tutor can refer to different materials. So these are the core materials, guidance notes, and then these are the materials that we have to use basically to prepare our notes. Okay.
correct.
So this is up to the tutor. So sometimes they go with the earlier edition, or I don't know which one they use. So as much as possible, I use the correct edition what they have told, because this also, along with the syllabus change, the tutors have to look at this one, fifth edition, fourth edition. They have changed because in the fifth edition they would have added some case laws. Okay.
Hmm.
And prescribed cases that are not included in this particular text are available on online, can be. That is 2025 cases, they are here. This is also updated. But other than that, so this we have to use. The case laws from Canley we have to use, which is given in the syllabus. They have given the link for those cases. Then articles are not included in the text. So that's why these are additionally given. Okay. And those are available free of charge online. So that also we have to include while preparing our notes. Then there are supplementary materials also. So what we have to do is, like, I have read this particular material. So some of these, no, I have read and I've included the content. Not everyone does it. It's not, compulsory. These are the core materials compulsory, but supplementary material definitely helps us understanding the concept much deeper, especially as a tutor, the person who teaches, we should know much more than the person who writes the exam, right? So for that purpose, and then these things like this act and this case and all, no, Margandela case and all those things, these are given in the Bryden text. So he explained the concept of feminism with the help of these things, like how it happened, right? So olden days, what was it? And currently, what is the stage? So that's what he used these things to explain basically. So that's why it's there in the note. I wouldn't say like everybody should have it, but without explaining what happened before, talking about feminism perspective on law is very difficult. So they should have mentioned it. You don't have to worry if you're getting this exam day assistance notes, it's mentioned here. So you can
Okay.
see here, feminist perspective on law, look at the extent to which the women are disadvantaged by legal rules and institutions that arise in societies that are patriarchal and such as to the interests of women and fail to account for the experiences of women in the creation of legal rules. This is what is the meaning of feminist perspective on law, right? You don't have to go to laws. Everything is over here, right? And who are the more famous names that comes in this particular theory? These are all in the that prescribed book. Okay, but why I'm mentioning here is that the main reason why I wrote these famous names or theories is because sometimes in the exam questions they ask with a statement given by some famous personality. So it's not there in my notes also. These people's names are not there in my notes also, and you wouldn't have access to internet during the
Hmm.
exam. So you should
Yeah.
at least be able to, okay, Emily, where is it? So it will come under some theory. So you will go to each of the theory, try to see that, okay, Aristotle, Plato and all is here, it's not there. Then you go to the next one. So these things you don't have to buy out on the day of the exam. If they mention anybody's name with respect to theory, for those five theories, you just look at this part of the material and you can see that, okay, Emily Murphy they are talking about, it is connecting to. feminist perspective on law. So you get an idea. Okay.
Okay.
So that's the only reason I have mentioned the names over here, nothing else. You don't have to mention this part in your answer. This is not part of the answer. This is just a hint for you. That's why this is exam assistance notes, not the IRACS, which you will directly apply.
Right.
Okay. So this can come under your introduction part. So I have written what this theory is or what is the meaning of this theory, but you will write this as your introduction, slightly changing the sentences, making it in your own words. So if you just read this material entirely, for the next 2 days, you'll get a lot of sentences, and you can make it in your own. So at least one set you have to read, so that you know where exactly what material and what it says. So instead of just referring it on directly on the exam.
Okay.
Then perspective as per the syllabus. So now in the body. So you can talk about. So give us separate side heading for this. Okay, don't mention that perspective as per the syllabus. This is for you. So the theory gives examples of person's case and Edward's case to show how the patriarchal society and institutions have disadvantaged women. Disadvantaged, okay, women. In 1980, in Parliament passed Women's Suffrage Act, then which gave every female British 21 years to vote. And this is the Edwards case. Okay, there's 3 lines, so you don't have to go through your notes. Then impact of no voting rights. So this is what I have added. The women who
Mm.
are subject to all the laws, but they have no say in selecting the representative who will make or enact the law. This is
Mm.
the aggrieved part, right? So
Right.
what is it that it did? And before that, what was the problem with it? So we are subject to the laws. We are supposed to follow the law that those representatives are making, but we don't have any say in who is being elected. And there won't be any law for the protection of women, have the MPs, elected people, right, have no responsibility or obligations on female because they are not the voters. So usually you also see the politicians will come and beg you for your vote and promise you that they will do something for your benefit, right? Otherwise, why would you choose that person over the other
Right.
person? You think that, okay, this person has something for my beneficial, my benefit, right? Then you will vote. This person is about thinking about me. If the women did not have the right to vote, they will not be asked for vote and they will not be promised
Yeah.
anything. People will not think about them. Then
Right.
what happened in person's case? So basically, it's like summary of the entire this concept, whatever was there. So this much quantity of material should be enough for you to make an essay out of it and write your
Agree.
answer.
Yeah. Yeah.
Then
Okay.
there is the syllabus case law, R versus Morgan Taylor. Then what happened here? The impact of this law, if it was held valid, if it in case that case they had mentioned that this law was valid, but they held it was not valid because it was in violation of section 7, right to life, correct?
Mm-hmm.
And right to life, liberty, mostly more than life, it was liberty also. So it would be directly affecting women and only women if it was held valid. It won't affect men, right?
Right.
Abortion laws, will it affect men? Even today, it
Not.
won't affect. It is only affecting women and taking away her choice. That's why I told liberty. Her choice of abortion outside the hospital premises, it was a violation of women's charter rights. In charter, you can see, okay, one point I would like to say, because in constitutional law framework also they wanted to, slightly know about the charter here as well. So what happens there, you have to remember, when did the charter come into existence in
It
Canada?
was in 1982.
Yes, 1982. So 1867, that is when the earlier constitution law,
BNA.
right? BNA Act. So that time there was no charter. Okay.
Right.
So any question comes that is talking about, old act, then you have to talk about the charter came into existence in 1982 with the new Constitutional Law Act of 1982. And that is the main important change that happened. Two things changed. What are those? One is charter rights. Second one,
The repatriation. Oh, sorry,
what
sorry.
are
No. No, what you're talking in reference to what?
the new act, 1982 Act.
That they patriated it, right? So they could make the amendments to the constitution. I
Yeah,
think that's what.
okay.
Are you
Okay.
talking about that or something else?
No, that is also good one. Then there are three things. So one more thing that happened with respect to foundation, it's really important related to chapter two.
Charter,
Chapter two,
mm,
Aboriginal
chapter
related.
2. Okay, yeah. So, the section 35, right?
Yes, exactly. So section 35 question might come separately also. I mean, I was very lucky. I got a separate question in section 35. It was easy. That had to write, right? But section 35 is something that came for the Aboriginal peoples, like protection, right? Constitutional protection. First time they got a constitutional protection. Now they can fight for the duty to consult and accommodation if they are not consulted. It is not consent. They don't have to say yes, but they have to be consulted.
Consulted. And if
Yeah.
possible, accommodated.
Yes, exactly. Accommodated. So they have to be consulted and accommodated, and the fair chance has to be given. Again, the judicial review concept comes there, right? If they are not given a chance, then what happens? They have a fair chance at judicial review.
Yeah.
Then you will write about, because there is no articles on feminist perspective on law, you will write about your opinion. It is greatly important for the society to maintain equality and order. The law has to equally support women and men, and because of the feminist perspective on law and the constitutional fight, continuous fight today, we have voting rights, women senators, laws that do not violate charter rights, laws that discriminate based on sex is invalid, isn't it? Because under section 2 15, section 15 of the charter, we have gender is also one of the
Yeah. Yeah.
point, right? So therefore, in my opinion, this is the most necessary theory or important theory in order to maintain fairness and justice in the society. Therefore, in my opinion, it is the most necessary theory. I've just repeated this one. I think this should be cut off. Okay.
Okay.
Yeah, this was supposed to be in the conclusion. So basically, what you say is here the theory answers are
You're
slightly
right. Like,
different.
it makes no sense for me to compare with critical legal studies when they've not asked to compare.
Yes, but sometimes they might. So that time, what you have to do? You have this answer. You have the critical legal studies. So you will. There are more names over here. Okay, for the critical, of course, men also included. So, so we have more names over here. So just see if they have referred to any particular person. Then mention that he was a theorist of who supported critical theory, legal studies, and more than that, you don't have to write, just talk about what he said, like it'll be about concept. So here also I've written, if gender bias only apply feminist perspective of law. Many times students get confused that if there is a new, they are criticizing the law, it could be critical legal studies. No, just look at it. If gender bias, then it will be talking about only feminist perspective on law. Otherwise, critical legal studies you will talk.
Okay, great.
Hmm.
Great.
So basically, this gives you a complete material basically out of which you have to make your answer. So you will make your answer with respect to like introduction, then body, then conclusion. In body, you will write the heading of the theory, okay, and background you can mention, right? Heading of the theory, you will say what is it, the meaning you can write, or any proponents or any perspective like that you can write, what it contains, what the theory contains you can write. Then you can talk about what did I say? Background, right? So sometimes I write background. If there is any historical things to say, especially for Aboriginal and the theories, we have something to say from the past. So you can write about background. That could be one of the side heading for theories answer. Then the present scenario or the impact of this theory in the present day. Like that also you can write. So that's basically up to you. You can write whatever side heading may suit for that answer. But before writing the answer, you can refer to this short note on each of the topic. So connect with the one or two topic, whatever is necessary. Sometimes it will be specifically one topic. Sometimes it may be two topics. Refer to those two and make your answer.
Great, great. I'll do that.
Yeah.
Do you want to like stop for like 10, 15 minutes now and then start the next hour?
No, I'm good. What about you? If you need a break, I can give you.
I think like we can just stop for 10 minutes because I'll just get something to
Sure.
eat.
Sure,
And
sure.
then so now just 10 minutes is fine. So we can start at like 11:50 or something. Oh, sorry, it's 11:50 for me.
Yeah,
What's
it's
the time?
15 minutes, 10 minutes. No, I'll just set a timer for 10 minutes and
So
I'll
it
reach.
is we can start at 1:20.
Yeah, sure.
Okay. What do you want to do exactly? You said you want to ask me questions, right? I think that would be a good approach.
Yes. Yeah. So I'll
Okay,
be
okay.
asking you questions, and last half an hour, what we'll do is I'll open the sample papers, sample questions, not the one on the NCA, the other one. Okay?
Okay, great. Okay,
Yeah.
I'll start again in
Yeah.
1:20.
Sure. Okay. So, in first chapter, like we understood, right? Like any question comes from a theory. So, how we have to answer that particular question. So now coming to second chapter, yeah, second chapter we have multiple, parts in it. A, B, C, D,
Mhm.
E. I think five parts are there.
Yeah,
Yeah,
right.
yeah, five parts are there. So from each of the each part, there may be some individual question. I think this is the only chapter where, like, from each section, there could be a separate question, and there could be more than one question from chapter two, because there is a
Okay,
lot to cover over here.
right.
So here the topics are Aboriginal rights, title, indigenous self-government. This is one, and modern treaty making process. Do you remember on top I told treaty making process is important, and this is just about the process, and there is an article about it. So that's also theory. So yeah. So here Old Act 1867, we have Section 9124, which deals with the power to make the laws on. So 91, Section 91 and 92 are basically talking about the power to make the laws,
Yeah,
um,
federal provincial.
federal government or provincial government. So Section 91 means who's the,
Federal,
yeah,
federal.
yes. So federal government has the right to make the law on indigenous people, that is related to indigenous people. So this is just talking about just the information about legislative rights. Okay. So that is with the federal government. So any law that has been that is being passed, or if a provincial government is planning to make a law, so can they do it? No, because it is given to the federal government under the division of legislative powers. So that's how you're going to answer. In case any question comes about that, not necessarily, it's not that important, but just for remembering, we should know how they might ask question. If I was an evaluator, I want to trick you. I would say that, province of Manitoba wants to make a law for the betterment of, like, considering the truth and reconciliation and previous atrocities on indigenous people, and they want to, make a law which protects them, so and so, so and so. Something good they will mention, definitely. Okay. So that is basically to confuse you. But the main point over there, so they will mention how these was the issues and this is what they want to implement, and this is going to be best situation for Aboriginal people. And now, do you agree that they can do it, or some angle question they will ask. So that time you have to mainly see that which government or which legislature is planning to make the law first. Then, if you find out that it's province of Manitoba, which does not have the legislative powers to make the law, that means under Section 9124, you have to quote Constitution Act of 1867. You have to say that this power is with the federal government. So, under division of power, what do we say? If they go beyond their power, so that means it's ultra virus. That law, if
Mm-hmm.
they enact, it will be ultra virus. Any law, it's a very good intention. Yes, there was atrocity. So you will, because otherwise, it's just one paragraph answer, right? So you will say that yes, there was atrocities, yes, there was this thing and all those things, but it all goes back to who has the legislative power to make the law. It is given to the federal government, and if such good changes have to come, then it has to be enacted. Such law has to be enacted by the federal government itself.
Right.
Okay. Then we were talking about Section 35, right? Section 35. the importance of Section 35 they might ask. Let me show you. Section 35 basically duty to consult and accommodate, right? So they might directly ask the question asking about Section 35 in their question, or they might ask the question situation where the duty to consult and accommodation, or either one of that, was not given to the indigenous community when somebody or some institution was trying to take away their rights or title or the treaty rights. Okay, so anything that touches to indigenous people, their rights, title, treaty rights, it could be self-governance, anything. So that anything touches Aboriginal people, they have to be provided with this prior duty to consult and accommodate, not post. It is prior duty to consult and accommodate. So that time you can refer to this. And there were cases of Haida Nation versus British Columbia, which is a landmark case, right? And Skelcott Nation versus British Columbia, Thames case, Clyde River case is there. So these are the cases. Sometimes they also might ask, like, there were a lot of case laws which gave the development of indigenous people's rights and their recognition. So would you elaborate on like these cases? So that
Right,
time
right.
you're not just saying that what happened in those cases or like what was the verdict. You're also going to talk about the impact of that to the indigenous people today.
Hmm.
Okay, there you can connect with the president also, but mainly you're going to talk about this was like background. I told you. So in the body you can mention like background, slightly little bit about anything that comes about Aboriginal law. It's easy to write. I'll tell you an easy formula. In the background, you include uh, this one, introduction article. Okay,
Okay.
because this article has very painful depiction of the truth that happened earlier, right? So the residential school issue, or
Hmm.
earlier atrocities, like how the children were separated from the family. They were not even let
Yeah.
themselves speak the language, right? Their own mother tongue. So all these
Right.
things happen. So yes, the previous atrocities that happened. So background you write. So why it is important, right? So background you can write, and then the development, slow development, like that also you can give. And then you can talk about where it started. 1982 it started with Section 35, where the Constitution of Canada, it recognized Aboriginal people's right as a constitutional right, and it gave them duty to consult and accommodate, right? And if
Hmm.
the question is mainly on 35, you write more about DTC. But if it is not about that, if it is something about something else, then you write slightly about Section 35, but that will be included. Okay.
Okay,
And
so you're saying like in most indigenous questions, the background, like you put this TRC introduction article because it
hmm,
gives like a nice,
yes,
introduction about, and then the
yes,
development is through case law, section 35, all of that.
yes, yes. So that will be, good answer to start. Let me show one sample question and answer on Aboriginal. See, the introduction I started with. So here the question, nature of Section 35 itself suggests that it be construed in the purposive way.
Hmm.
When the purposes of affirmation of
This
Aboriginal.
is
So
combining chapter 2 and chapter 9.
yeah. So here it is affirmation of Aboriginal rights. This is one more thing like you have to remember that it's not that Section 35 gave those rights. It is not the origin.
Affirm. Yeah.
It
It's
affirmed.
already
So
there. It just
it was all,
affirmed.
yes, yes. It is already there. So earliest scripture, what you can remember where the Aboriginal rights and title, Aboriginal rights basically was, recognized. Do you know?
Sorry.
Do you know that any earlier document other than this constitutional protection is 1982, correct? But before that, there was a document, the first document. Do you remember any document which where the Canadian government was promising certain rights to Aboriginal people?
The old treaties?
Yeah, the first treaty. Do you remember the Royal Proclamation,
Yeah, that's
1860
17. It was
something?
in 17, I feel, 90. 18?
1763. Yeah,
Yeah, 17.
1763. So here it is. The 1763 Royal Proclamation. So that is where, the legislative history I have mentioned. So that's how you can, write your answer flow. So you can start with, so any question that comes with your Aboriginal, people. So you can put the elements of section 35 over there. Okay. And then you can put about the history, because here it is directly about 35. So here it is. But otherwise, you can directly go to the history. So legislative history, how it was. So Aboriginal rights recognition traces back to Royal Proclamation of 1763, which acknowledged indigenous land rights. However, only in 1982 these rights were formally entrenched in the Canada's constitution, and it affirms so and so things. Then we can see. Then case laws. There were R versus Sparrow, which talks about, because the question is about that, so we have put that ahead. Otherwise, you can mention other case laws also, whichever is more resonating. If they're talking about title, then skill coordination, Haida Nation, then there was one more, Vanderpeet, that is for
Yeah,
Aboriginal
Vanderbilt.
rights. Yeah, Marshall case for treaty. So from constitutional law also, we can take some
This
topics.
document is which one? Which document is this?
This is question and answers.
Is this the one which I told you I'll purchase?
Yeah,
Yeah, okay. Where you said that there are 32 questions or something?
yeah, this one should have,
I think you said there were 32 in total or something.
yeah, that should be another file also. This is 33 pages.
Okay. But how many questions and answers are there? I think
Yeah,
there'll be then at least one for each topic or something like that.
yeah, this covers like most of it. Let me see. Question 10, I think it
So
is
there are
great.
10, I think.
Yeah.
10, each topic one.
Hmm.
And you're following that style, right? That IRAC
Hmm.
essay.
Yeah. It's
Okay, so this is the one
abdomen.
which you told me that I told you yesterday I'll purchase question answers and all.
Yeah. So this is from practice questions and detailed answer. Yeah. This is the one, and I also have like something else I will show you in some time.
Okay.
So this is having 10 questions, right? Actually, there is one more.
This
This
is
is
different.
topic wise. Yeah, this is topic
So
wise because
what is the difference between that document and this one?
this one was prepared for the, topic wise. Okay, topic wise. But the earlier one was from the exam questions. Like from, these are all like from previous papers sort of type, like how exactly it was asked in the question papers.
Oh, these are from past question papers, like
Yeah.
past sample exams, because question papers, how do we know?
I mean, question papers in the sense like from UBC only, they also refer. Like if you have seen, there is a pattern from like UBC questions and in NCA exams. So
What
usually
UBC?
for University of British Columbia,
No, no, I know that. I mean to say,
Mhm.
what do you mean UBC questions? Like in their
UBC.
course, the course that they offer.
See, yes, so they are LLB course, no? Because the MCAs are like in parallel with that only, right?
They are
they want
JD
us to know,
course.
yeah. So their JD papers are there on their website. So for sample practice papers, of course, you know that from NCA we can't have any direct connections, right? So from past papers and all we can't access. So, but there is a lot of similarities with the fact pattern and like question pattern from UBC. So from there, like previous, I think 4, 5 years, 10 years papers are there, and so from there, like we take, but slightly I rearrange it to what I have heard about, like what was the question type. So That's how these questions were made. But
Okay,
these,
so this document has those NCA similar to that, and the other one has your own questions.
yeah, these are basically to, test whether the person knows the concepts or not. And if, some types, these type of questions has not at all come, right? So extra questions. So,
Let me just have a look at one of the questions. How is the question framed?
yeah, let me
These are
see.
like your own questions, right? So it would be it's
Mm,
there's no question. You've just where's the question?
Wait.
Okay.
Hmm. Support your analysis from this case law, like that.
Okay, okay. Okay. So
This
this
is a
also has
mixture of
10
all.
answers and that also has 10 answers.
This one, let me see. The chapter wise I had made. Yeah, this is only on the first chapter. All the theories, because there was no much questions on theories, so I made theory questions. This is all for chapter first based on theories. But I'll tell you, like honestly, if you have this material, you can make up all the answers. That is exam day assistance notes. Along with that, if you have this question and answers, then you get a flow of the exam type of questions, what type of question they might ask, and these blue color is basically the hint that from the question, these are the hints that I got to connect with the topic that I'm writing answers to.
So these
That,
two though I'm purchasing only, this exam
yeah,
assistance and this other question
that
I'm
I'll
not
give along with that. That I'll give
what
along with
but
that. You
is
can
this for
see.
each topic or you said it's just one topic or something? I'm confused.
This is the chapter one because there is not much questions on theory over here. That's why these are
So
additional
this
questions.
this one is for which chapters? Which chapters does it
Chapter,
include?
first chapter.
Only chapter 1.
Yeah, this one is only chapter one.
This full 14-page document is just chapter 1.
Yeah.
Oh, okay, okay. Hmm. I
So
thought
you
you said
can,
it's your own question answers.
yeah, own question answers made for this chapter only.
Only chapter 1.
Yeah,
Oh, why
yeah.
only one chapter like?
Because in exam they don't ask much questions from the theory. Okay, so
Uh,
in one of the batch I was teaching, so I was requested by the students, can you make questions on chapter one, because there was not much questions on the question and answers or even NCA exams, right?
Okay.
So yeah, so that's the reason why like I made these question answers so that students, they should be prepared, right? Even if the question comes from feminist theory or whatever other theory or something, so that's why. But that time, this particular material was not there. This particular material was not there. It was prepared later on. So we have this additional
And
material
what's
on
the
this page.
second question answers? The second document. Yeah, this one, right?
This one is the
This,
one you saw. The, question answers, which are 10 questions from different chapters. We have
okay. So
in the exam pattern.
you have only two documents of question answers, right? One is this, the 10 questions,
I
and
have
one is
more
that
actually. I
you
have
have more.
more. Yeah, yeah. So if you see, there was this Mathur case which was added. So these are all like specific to that particular chapter, like section 7 update on Mathur versus Ontario case. So let me see if it is still there in your
No,
syllabus.
it's there,
Mathur,
it's there, it's there, it's
huh.
there.
Yeah. So
No,
then
but I
you,
don't want to purchase like one, like just this one case like that. I
mm-hmm,
want to purchase the documents that you have, which are covering questions from like all topics mostly. So
mm-hmm.
that you have only one document, right? Which
Yeah,
is like,
yeah, yeah. So that is the question and answers which are more similar to exam pattern. Okay. So that
and
is
then that
the
other document is just the chapter 1.
other document is chapter one, like that. Chapter 9 is there, chapter 7 is there, questions on indigenous law is there, like that. Separate is also there. Okay. But I would say that for printing out, you can keep that question and answers, okay, which is
And
the 10
exam day.
questions. So, and exam day assistance. But when anyone buys question and answers that file, I give them these additional questions also, but they
Great.
can refer it to,
I
this one,
think I would
soft
like
copy.
to have this questions on indigenous because indigenous is a very big topic, no?
Yeah, yeah. Then you have sample answers to NCA question paper.
Yeah, yeah, yeah.
That will also be given. So basically, when I say question and answers, all the files, okay. But
Great.
for the printing out, I just say that 133 pages and then the exam day assessment, that is more important. So it is made separate file.
Okay.
Then we have mock exam also, so which you will be writing afterwards and sending me answers. Okay. So coming back to the syllabus. So like I was saying, anything coming from the indigenous law, you can, touch upon each of the topic, but make sure that you are making, giving proper reasoning for the question that they have asked. So same pattern like earlier we were discussing, introduction, body, conclusion. In the body, you will talk about little bit of history. The history will, you can use introductory materials for the history part. Then if they are specifically talking about self-government, then your 70% of your answer should talk from this part. Okay, whatever supports your answer. So you can take, sometimes, students ask me, like, do I have to mention all of these or only some of these? What do you think?
I think what's most relevant, right? But I
Yes,
think mostly you can
yes.
touch on more. They're just five, so you could talk about four or three of them.
Yeah, exactly. So if there are five, talk about three. And if there are, check here, one case law is there. So definitely that case law I will write. Only
There's
one
two
case law is
cases.
there.
Even references. No, that's an
Yeah, yeah.
act. That's an act.
In respect of,
That's
yeah,
an act. Yeah.
I think this is case law only.
Is
Yeah, Canley, no case law. Yeah. So
Yeah,
this
yeah,
is
it's a
also case law. You're right. So there are two cases only. So at least one case out of these I will write. Okay. And if my case is definitely connecting to this case, I will write this case. I will leave this case. Okay. And most recent is most good. So like that. So when you are arguing with the court also, you will go with the landmark case. Otherwise, you will go with the recent case, right? So if the
okay.
landmark case is more relevant for you because you have to talk about the test given under the landmark case or something that was upheld and still not overruled, and today also we have to rely on that case, then you will go with the landmark case like skill coordination or Chippewas or Clyde River case or all those things. So anything that is more relevant, you write that, and then one with the most recent. So I always go with, like, when I'm submitting any materials for um, any assignment or anything. So somebody told me, go with the oldest case and then with the recent case. So this, when you apply, so your research is complete. So they think, like, even the judge will be impressed, that okay, you have done your research from the start till the present. So
Right.
you have seen the development of cases. So
Right. From the older.
again, yeah, again, writing about different cases doesn't mean that you are talking about, okay, in Chippewas of the Thames First Nation, this case, how this was happening and this was the decision. No, you're saying that what did you get out of that regarding Aboriginal rights? Which Aboriginal rights specifically was in this particular case? So let me see if I have that image. Hmm. So there was this image of my syllabus, foundation syllabus copy, the one I had on the exam day. It had written all, like I had written all the small, wordings over here, wherever the gap is, which gives me the hint to what happened over there,
Hmm.
right? So like that, you can also make some notes on your on your syllabus itself. Like for example, if Chippewas was talking about Aboriginal rights, there are multiple rights, right? Whether it is fishing rights, whether it is right to for particular thing. So what is that? So if you write that here, it was fishing rights, here it was right to hunt, hmm? Right to resources, something like that. So that might help you to jot down the which case is more relevant for your question, because in the question they will be talking about specific right. They will not say generally, okay, they are fighting for Aboriginal rights, but which right? They will give a scenario about this is what happening. They are trying to, the in Haida Nation case, what happened? They told, they gave the license. The Haida Nation was British Columbia, right? So British Columbia government basically gave the license to a company to cut down the trees without doing the duty to consult and accommodation. Correct? So now there is a similar fact pattern they might give. So that's why it's important to know the fact patterns of especially Aboriginal people's case, Aboriginal, chapter cases, because similarity is seen with respect to fact pattern. So that time you will understand, okay, if it is about cutting the trees, if it is about, without duty to accommodate and consultation, is the license is given, then it directly connects. They are talking about hibernation. So you will see that the facts of this case is very similar to hibernation versus British Columbia, where this happened. And the court held that the duty to consult and accommodation prior to giving the license was necessary, and they upheld the rights of the Aboriginal people of Haidna Nation community. So in Aboriginal people also there are multiple communities. They upheld the Haida Nation community. That doesn't mean in the question, whatever community is there, they also have that, same right to hunt or take the bark, whatever. But that will be decided on case to case basis. But what is the principle that is similar here? Both are Aboriginal people, and both Aboriginal people are protected by constitutional law, section 35, 1982. So
Right.
that is the similarity. It may be different from, they want to hunt over there, or they want to cut the trees over here, they want to take the bark over here, slightly different. They want to take the fruits over there. That may be different, but the similarity is where both are Aboriginal communities and both have constitutional protection, which was upheld by this case and also followed in the recent case of so and so. Any recent cases there? And moreover, this article, so and so article, talks about the Aboriginal rights being upheld time and again, and still there is not much, practical approaches to their protection. Still, they are in a situation where they have to come to court, they have to fight for their duty to right and duty to consent and accommodation. That is what happening. Some article might be saying that. So write that article. Then, in my opinion, in such situation, practically, yes, it might be difficult. But legally speaking, or when we apply the law, when we see the position of law, the law is very clear where it protects constitutionally the right to consult and accommodate. It does not mean consent, but it is the consultation that they have to do prior. So in this case, this government or this particular provincial authority has not consulted the Aboriginal people of, so they will give the community name. So make sure in your answer you rewrite the community name, you rewrite the dates, you rewrite the area or whatever the right specific right they have mentioned. This is how you make your answer more personalized. So they will know that you have not copied from anywhere. That's the most impressive part, that you can score more. Okay.
Mm.
So when you write from your mind, then only you can do all these things. If you're referring to some notes and just writing the theory, then they will clearly know. Then it will kill the
Yeah.
mood as a evaluator for me also. If somebody is writing, all theories, that is like it's an open book exam, right? So that is why people are not getting marks. Some students will say that it was so tough. I just wrote something and I'm not sure I'm going to pass, but that student will pass. That student has passed because they thought it's tough, but they wrote something directly from their mind. They applied their mind. They wrote directly from questions, points, and they wrote their opinion. Even though it felt tough, but they passed. But the people who came, the exam was easy actually. Everything was there in the notes, and I just wrote and came. That person has, lost marks because for theory, for what you write from the textbooks, they don't give the marks. It is for the application and reasoning they give the marks.
I have a question. Just
Yeah.
want clearly understand the difference between aboriginal rights and title. Like I know title refers to title to land,
Hmm.
but I want to know because like you know how you the treaties deal with aboriginal title to land and establishing
Hmm.
title, like when a claim is made, the duty to consult once a claim is made, before a claim is made. But I want to know, when you talk about rights, is it just more related, like obviously you talk about like rights to fish, hunt and all of
Hmm.
that, but
Hmm.
what exactly would be the content of the rights other than that? And if you are
Yeah.
separating it from title.
Yeah, that's a good question. So in constitutional law, we go much deeper into making this distinction. Good question. So see, Aboriginal title is also a form of right. Okay,
Okay.
because it is a right to the land. It is
Right.
specifically to the land, but it is also a right.
Right.
We can't actually put it in a separate category. But why it is put in a separate category as your chapter is because it is a very
Strong right.
repetitively questioned thing. And title is a bundle of rights, right? Bundle of rights related to property, right?
Right.
So now in Aboriginal title, the ownership of the land. So in property law also, if I connect to that, and we see that ownership is nothing but bundle of rights related to property. So whenever your question is talking about land and they want to live in that land, whether it is possession, whether it is ownership, okay, let me question you. So Aboriginal title, do you think they have the right to transfer that particular ownership?
So it cannot be transferred. It's only transferred to the crown. It cannot be transferred
Yes.
to anybody
Yes,
else, and it's a communal
yes,
thing.
it's a communal right. It is not an individual right. So that is the difference between the normal title of a
Property,
property
yeah,
of a
yeah.
me
It's a
and an Aboriginal person.
sui generis, right? So it's very
Sui
unique
generis.
property,
Yes,
right?
yes, exactly. It's a sui generis, and that is the difference between the general title to the property and Aboriginal title. That you are perfectly clear. Okay. Now coming to Aboriginal right. Now, Aboriginal right can emerge from anything. Now, Aboriginal right can emerge from a treaty. If it is emerging from a treaty document, that means it's a written contract. Then it is a Aboriginal treaty right.
Hmm.
Okay. If it is not emerging from a treaty, but it has been recognized earlier in some manner, that could be, Vanderbilt test. They say that how can you prove an Aboriginal right if it is not under a
Integral
contract?
condition. Yeah.
Yeah, if it is not under a contract, then you cannot prove generally, right? But there is a Vanderbilt test given with 10 points where they say that from it is connected to your spiritual, cultural things, right? So basically, just one point I would say that is it is connected with your community culture. Then you can say that yes, it is my Aboriginal right. So that's the distinction you can make. If it is coming from a document that is a contract, it is called as Aboriginal treaty because treaties are made between the Crown and the Aboriginal community. So if it is recognized under a document, under a treaty, then it's a treaty right. That is also a right. But it is a
Right.
coming from treaty, so we call it as Aboriginal treaty right. Then you talk about
And then you
treaties
have
and
the
all.
general rights, which are like not through the treaty. And then obviously, as you said, title to land is also a right. And then
Hmm.
you also have title to land, which is recognized in the treaties. That's the main source.
It could be, yes. Title to the land is but not given. Okay, so far, otherwise it would have been so easy to prove, right? Aboriginal title is made a separate concept because there is a clear test given how you can prove Aboriginal title. But
Right.
whereas for Aboriginal rights, other than the treaty rights can be proven under treaty. Title can be proven under Aboriginal title case, right? There is uh, another case,
Continuous
not
sufficient
yeah, yeah,
occupation.
yeah. Not this case. Before that, Delgamove case. Delgamove case is there, no? So that is the first case where they spoke about the test of Aboriginal title. Not in this case. This case, they applied that test and they were first time successful. Do you know the
But
Delgamove case?
I do have it 1 minute. It's in front of me.
Huh.
In Delgamove, they said, yeah, test is to proving occupation continuity and exclusivity.
Yes. So that is the first case where they got the test clearly. In
So
1997
you're
also,
saying that Delgamove they got the test and Tishilkot they applied it.
successfully applied. Yeah. In Delgamove, they couldn't prove. Okay. Delgamo, they couldn't prove, but the test was very clear over there, and that test was still applicable, right? So the same test was applied in 2014. So you see 1997 and 2014. How many years, right? So now 2014, it was the first time when they got successfully, they could prove that yes, the Aboriginal title for skilled coordination people was given. They could prove those three pointers in the test. So now Aboriginal title can be proven in this manner. Now, what about the remaining rights? Right to hunt, right to fish, which are not recognized under treaty or it is not related to property. So we can't apply the Delgamo test also. So
Right.
for that we have Vanderbilt test. So that's
Random.
why the distinction is done. But all these things are rights only.
Right. They're all rights.
All are rights only, but they are categorized differently because uh, the nature of the right. how it can be proven in different, what is the easy route? Treaty is easiest route. Title is then the second easy. Then the remaining part is we have a Vanderbilt test where it's little bit ambiguous, right? It's a bit vague also, but somehow we can prove that because of the cultural connection. There are 10 points over there given, so you can prove under many of those points. Then you can say that yes, it was an aboriginal right which can be recognized.
Right.
So that's what under this Aboriginal rights, try to see each case which right they're talking about, so that you can use that particular case if that is being asked. Like petroleum geoservices, this gives me a clue that it might be something related to excavation, right? So mining rights. So if it is about mining rights, I'm not sure and I don't remember it, but try to trying to connect it. So if it is about mining rights, just write the mining rights part here. Then if it is about fishing rights, then write fishing rights here. Like that, if you write now on the day of the exam, it will be helpful for you. You will refer to this case if it is about fishing. Okay?
Right.
Yeah. So that's how you can make a distinction. The standard of review and the duty to consult accommodation in Indian people. What is impact of waiver law? Okay. In administrative law, you have studied Vavilov case, right?
Babylon.
Yeah, Vavilov case where they told about standard of review.
Hmm.
Standard of review, which type of standard of review has to be done? There are
So
two, right?
basic, yeah, basically, for they said in Vavilov that the court will not do an independent inquiry. It will start with the assumption that all decisions are reasonable, and
Hmm.
so the deferential approach. But then, obviously, if there is a exception to that, it will be rebutted. So, in cases of where it's explicitly said that a correctness standard has to be adopted, they will adopt that. Where there's a statutory appeal, the different standard will be applied. Or in questions of law, constitutional questions like that, then
Hmm.
the correctness standard will be applied.
Yeah. So unless the correctness standard applies, then for all the following things, you have to apply
Reasonable.
the reasonableness is the default thing, right? You will always go with the reasonableness unless the correctness standard applies. So they have Wavelov has basically listed out like the 4 5 points, which will in those situations you will apply the correctness standard. Otherwise, you have to always go with the reasonableness standard. That is the decision given by Wavelov.
Right.
So, how does that help to understand the standard of review and the duty to consult and accommodation with the indigenous people? About as per the Robert Hamilton. What do you think? Because this is one of the important articles. So, what do you think was the perspective of this author? What does he wanted to say when he said this?
1 minute, I'll just have a look at my notes.
Sure, sure, take it.
So I think basically what the author is saying that like um in 1 minute. So there are four, there are triggers, right? There, 1 minute. In the duty to consult, you have 1 second, just 1 minute. So I think so basically what he's saying is that like Vavilov said that reasonableness is the default position,
Hmm.
but I think he's talking about the fact that it doesn't really apply properly in 1 minute. Why am I getting so confused? Hold on. Yeah, so he talks about like there are four distinct assessments, right? There's a trigger. The
Hmm.
when the duty to consult and accommodate applies, there's a trigger. Does the crown duty arise? Then there's the scope of how much consultation will be required. Then the
Hmm.
process of consultation, And
Mm-hmm.
then the adequacy, has the crown discharged its obligation? So I think what they're trying to say is the Vavilov, after the Vavilov decision, the court said that they split it. They said that the trigger and scope will be decided on a correctness standard,
Mm-hmm.
whereas the process and the adequacy will be decided on a reasonableness standard. And I think he's trying to say that he feels that more of it should be assessed on a correctness standard.
Yes, correct, correct. Yeah. So, so while telling, applying this particular article in your answer, you would say that, there are two authors, right? Hamilton and Kislovitz. So there are two authors. So these people can say that the correctness standard is more going to uphold the honor of the crown and ensure that accountability in fulfilling the constitutional obligations of the indigenous people. Even though it was split after the waiver of whatever DTCA cases, duty to consult and accommodation cases. So these cases had split, rightly how you said. So these come into one paragraph, right? So RMC, you can apply this particular article into your answer if they're talking about DTCA, right? If it is, if
Right.
a question is coming about duty to consult accommodation and there is a concept of, judicial review also, then you don't have to go to chapter 10. It is not about chapter 10, but there is a judicial review article in chapter 2 itself. So this article
Right.
is going to be applied over there.
Right. Right. So, but just to confirm in this
Hmm.
article,
Hmm.
I was also seeing on ChatGPT because I was confused about some parts. Is
Hmm.
the author saying that all four, like everything should be under correctness? Is that what he's saying? Because I know he's saying more of it should be under correctness, but is he saying all of the steps? Because he also talks about the fact that the C and D, the process and the adequacy, that's more of a procedural question.
Hmm. Hmm.
So is he saying that everything should be measured from a correctness point of view, or is he just saying that more of it should be?
Hmm. The authors assert that adequacy of consultation should be viewed as a threshold constitutional question akin to powers which attract correctness review. People approach align with the honor. Yeah, more of correctness only. All
More
to
of
the correctness. Yeah,
right.
they say that basically the consultation, the process of consultation also, because it is a constitutional right. Whenever there is a question of constitution, it has to go under the correctness review.
So
Correct?
isn't it going like the heart of it goes to the fact that Vavilov
Hmm.
decided that questions of constitutional importance are to be
Hmm.
decided on a correctness standard, right?
Correct. Hmm.
And this is a question of constitutional importance when it comes to indigenous rights, but they are still decided on a reasonable standard. So he's saying,
Because
why
there
is
is
that happening?
a
It's contradicting. It's not applying Vavilov correctly,
Yeah,
right?
yeah, exactly. But it's all about interpretation, right? So the courts also, they looked at the Vavilov. They said that it is not a question of constitutional importance. It is about the process. So reasonableness makes more sense for them in that context. But if you see, there are, case laws where it comes about, major case laws and all in Supreme Court. There is assenting view and dissenting view. There are
Mm.
judges who are going to support the majority. There are minority supporting judges also. So interpretation again differs over there, but it goes as per the majority. That's why the decision looks sometimes different from even our interpretation or your author's interpretation.
But actually,
But
it does make sense because they're saying that Aboriginal rights are
hmm,
correctness standard, but this is related to the duty to consult and accommodate, which is a procedural thing.
yeah,
Like it's not going to the
procedural thing.
heart of the right.
Yes, exactly. It's a procedural thing. So majority, when they decided that yes, we will go with the procedural,
Reason.
reasonableness because it's a procedural thing and how it has been decided by the like we are giving deference to the decision maker, right?
Right.
In judicial review, it's always about like whether I'm correcting you, whether I'm giving you, you have submitted your answer and that is your conclusion. So I may say that okay, you are the expert, right? It's always about if I'm giving you deference, you have to be the expert in that field. So the court is basically saying that it's a procedure. They are the experts, so they know better. It does not mean that whatever they have done is right. They say that we will send it back to them for review again. They have to do it again. But correctness is where I change your answer. I say that
Right.
yes, you being the expert also, you have not done it correctly because it is something related to more to the constitution importance. So that's why you are not the expert in that. You may be expert in Aboriginal, people's concept, but this is related to constitutional thing. So that's why it is something I will rewrite your decision. I will not send it back to you.
Right.
Reasonableness always I have to send it back to you.
Send
I
it
can
back.
say that you're right or wrong. I will say that yes, you approach to the wrong conclusion, but you are the expert, do it again correctly. Okay.
Right.
But in the correctness standard, I will not send it back to you. I will do the decision myself because it's of the constitutional importance. Here, both are right in a way, right? Because constitutional importance is also there when we look at it in the angle of duty to consult accommodation that has been recognized by the constitution, and it goes to the core point that Aboriginal people are not given the fair chance everywhere. And if you again send it back for the reasonableness, point of view, then it may not get the justice that it requires. So the Supreme Court had to correct that particular decision over there, and they have to give the decision, right? Because again, if you see like that, these authorities, decision makers are in the provincial, right? In the provincial manner. But under
Mm.
9124, we know that the laws have been made by the federal government and the Aboriginal people. If you have read some articles and all, no, much deeper if you go, they say that we only recognize the crown. There was one case also where they say that we only recognize the crown, we don't recognize the authority of you officers. So we want
Okay.
the crown to come and do the negotiation with us. We want the crown to come and give the consultation to us. But there was a decision where they said that no, you can't because they are the crown's representative only. Crown cannot come everywhere,
Yeah,
right?
the third party. Yeah, third party.
Third
That
parties
was
basic.
to that case now where they said that the third party should have the statutory right and they should
Hmm.
inform the indigenous that a third party is doing the
Yes,
consult.
yes. And the Supreme Court also was right when they said that, okay, we will go with the correct reasonableness standard because even though it's rooted in the Constitution, it is specifically about Aboriginal people and we need experts to deal with it. We need
Right.
experts to deal with it, not the, general judges. The
Right.
judges, they are more of having general knowledge about everything, but they're not the expert in that particular field. So they should not correct it. Instead, they should apply the reasonableness standard for that. So in a way, both are correct. So you can make your opinion where you're, balancing both views and then, make a conclusion that I would, yes, I feel like this is, judges are right in this particular situation. Author's perspective also makes sense and it is respectable. But when we go into the root of the law, so you can support the law over there. Either you can support the law or you support the author. That is up to you. But you have to whatever we discussed, right? So basically, that you can inculcate in your answer in a paragraph.
Right. Okay.
Then title is simple. Treaty. There is one case, and on this particular article is also on that case. So anything comes about treaty, you can write about both.
Right.
And like I said, anything about, even if it is about Aboriginal treaty, you connect with the section 35, start from the beginning, DTCA, everything. And then this should be your 70%, but 30% you talk about the introduction also. Okay. Like other parts as well, because otherwise the answer will be very short.
Okay.
Hmm. Then here I've told, the precedent is
Yes.
for important. And then we have the equity, there is an article.
Yeah. Right.
So Erit Samet, so his article is important. Bijurism, not so much. International law, this one is important. International law and domestic legal order. So in this chapter, this is most important. Then the second important is mm, this one.
Yeah.
So I would like to discuss about this. So here,
Right.
treaty making process. So this just talks about what is the process, like how there are 5 steps or 6 steps.
5 steps. Yeah.
5 steps. So how it happens. So you just have to know those 5-sided links. Okay. Then you can talk about Barnett in his article. He, clearly explains what are the steps. And in your exam question, some step is missing. or some step with little bit, question mark, right? So about that step, you write little more. Remaining part, you can say that this has been followed. This is how it's supposed to be, and they have done that. How they have done that in the question, it should be there.
Right.
Okay. It's more of a process part. So much, not much for our analysis, but it's more of a theory part. Application part would be, Baker versus Canada question is there. So earlier there was an article I was telling you in chapter one about rethinking Baker. So where they were talking about, this Baker case, basically what happened. So Baker is was a lady who was applying for the
Yeah,
citizenship based on compassionate grounds, right?
yeah, children. And all.
So there were a few points given under that for what was the case points?
The duty for procedural fairness.
Yes, procedural fairness is the concept. So, for duty of procedural fairness, when it how it is recognized, right? In other cases, also we have been applying Baker in all other situations, right? So it's a landmark case, and so basically here they wanted to know about the case. That's why this is the case law they have given. So just know that Baker case, what happened, what are those 4 5 points of the test basically test how it can be applied. So in your exam question, if there is a situation, fact pattern where they're talking about procedural fairness is not followed, okay, and that time you can apply this particular case law and write about it. But very unlikely they will ask about it now. But just remember that procedural fairness also there is a Baker case.
Yeah.
Nelson and Hape again, like it's about this. This article could be asked federalism and respect for international human rights in Canada, institution, public policy. Mm, in this particular part, they could be asking about like how I told you a fact pattern, right? There is Mr. A, he's saying that there is an international law
Yeah,
which
yeah.
you are a treaty, you have signed that treaty, or you are a person who has signed it and made it the point that we will make a law on that, but you have not made it yet. So that's your duty. So international human rights are to be, respected in Canada. They had to implement that. So in order to implement, what is that gap there? It comes, right? So that is what the author is talking about, and from his angle, just how we did for the earlier Roberts article. Similarly, you're going to find out what was the author's perspective and what would be your opinion on his perspective, whether do you think you rely on his perspective, or do you think however the law, there was a gap, okay, it's okay, it makes sense, or it does not make sense.
Right.
So here I would go with the author's perspective in my opinion.
Okay.
Then in the next chapter, principles of Canadian
You
legal
said that you
system.
wanted to go through some questions or something.
Yeah, we will. Here, these are again like not that important. Here, it could be rule of law, one question. Okay.
Mm.
Then here, parliamentary sovereignty. There's a question on that in our question answers also. We'll go there. So this could be one topic. Hmm, this is not that important. Just
Yeah.
know which are the components, and anything that comes, of course, backup we have the notes, so you can refer from the exam day assistance notes. Then executive and its function also not that important. Let me see anything. Mathur ka I've given separate question on that because it was most recently added, no? So that you might be asked. They had asked. So over here, judicial independence is the most important topic.
Right.
They would
Right.
ask it definitely, and Calvin Dick's article is also important. So, author's perspective, your interpretation, that should be it. And here, approaches to interpretation, modern approach, they're going to ask a question where you can use the article. Then here, judicial review in the administrative action. This is most recurrently asked question.
Yeah, yeah.
This is just a theory. It's not much of
Yeah,
an
that's,
application. Yeah, this is the one that is going to be asked. And here they could ask from each of the article. Like they could ask about that AI, artificial
I
intelligence.
honestly, to be very honest, the first two articles are pretty good and I understood them well. The third one, I didn't understand how it relates to the topic
This
this
one,
art. Yeah.
Mapping artificial intelligence used in the government of Canada.
Like the first two
Okay.
are very directly related. Like I found the third
Yeah.
one not to be related to the topic.
Yeah.
I don't know if
Interesting.
I'm wrong or what,
No,
but
no, that's a fair, assessment. When I first read this, even I didn't understand. But see, we have to go a little bit deeper to understand these things. So, I'll tell you easily. So, the concept is about judicial review in administrative action, right? So, let me give you an example of what we can most relate to visa applications, right? So visa
right,
application is an administrative action. There is a officer, visa officer is the person who is called as decision maker.
right.
I'm the applicant. Okay. So now we know that they have integrated artificial intelligence to make the decisions and assess the files and make the short list, all those things. They have already done that. That is why this article is important because in decision making process, if you don't have a person to hold accountable for, right,
Mm.
then how can you apply for judicial review? Whom are you asking,
So they're
right?
saying that they're integrating AI so much nowadays to the extent that you can't hold any single person accountable.
Accountable, yes. It is all about accountability. Here is basically Paul Daly is, questioning about accountability. The angle is that. So we need to understand that artificial intelligence, of course, it's useful. AI is useful for making things speed up, right? Speed up the process, and many of the human errors will be avoided. But when it comes to judicial review, we need somebody, the official person who made the decision. Now, if an AI is giving the decision, right? So I cannot go under the judicial review for the action of that AI, asking for many of the things like procedural fairness. The emotional concept is not there over there. Like I can't ask for compassionate grounds. So it will only go with the set pattern, whatever is coding done to that AI. It will go with that. It's not its fault. But when it's a human, there is a difference, right? So basically, it is just connecting with that and
What is
questioning.
the author's conclusion in this? Like, what
Yeah,
does he, what, I'm a little confused with this article.
we'll see. It's been some time I read it. Paul Daly. Yeah. Importance of many human oversight in AI applications to importance of maintaining human oversight in AI applications to uphold the accountability and mitigate risks. So even though you are using AI, let's say like I'm the tutor, you have come to me for notes. I use AI to make the notes and give it to you. I don't
Mm.
overview it. I don't revise it and just give it to you. That's wrong, right?
Mm.
So what I have to do, here they say that importance of human oversight is important. Using AI is reliance on AI is a new
He cautions
generation
against
importance.
over reliance. He cautions against over
Yes.
reliance.
Yes, exactly. 100% don't rely on AI. Just, especially in sensitive areas while acknowledging its potential to enhance efficiency and accuracy when carefully managed. So, of course, you can use it to the fullest of extent, but only with proper review. And, it has to be overseen by the human, because ultimately we need to hold the person accountable. In order to uphold the accountability and to mitigate the risks, you have to keep a person who finally reviews it and passes that. You can't directly make a person apply for visa and then the AI will make a decision and it directly doesn't go like that.
Right, right.
Yeah, now we'll go to the question and answers. Chapter 4. So there's this question: Canadian federalism law illustrates well a clear divide
Right,
between law and politics.
right.
Yeah. Whether a particular piece of legislation lies in the federal or provincial jurisdiction is simply a matter of local application of doctrinal rules. The drafters of Section 91 and 92 of the Constitution Act of 1867 set up division of powers that remains clear, straightforwardly applicable, and adequate to Canada in 21st century. Now you have to comment on this paragraph. Sometimes they will, give some paragraphs and they'll say that comment on this. What do you think?
But
Right?
I'm saying like the first line
Hmm.
is talking about a different topic, and the second after that is a little different.
No,
Because when
no.
I read the first line, the first thought that came to me was the article about the prorogation of Miller, where they talk
Mm-hmm.
about how they confused legal constitutionalism with political constitution. Like, you know, how they upheld a
Mm-hmm.
convention and they
Mm-hmm.
confused that with the law,
Mm-hmm.
because a clear
Yeah.
divide between law and politics. But then the second
Hmm.
part is totally different. It's about federal and provincial, like 91, section 91, section 92.
Okay.
So I don't know if I'm right.
So okay. So no, that's a common doubt. But I'll clarify that. So it's basically one and the same. So the concept of division of powers, where they have clearly distinguished, Section 91 and 92 talks about the powers, legislative powers given to federal government and the provincial government, right? So the concept of federalism basically does what? It divides between the law and politics. Like they say that there are three organs in the government, right? So what are those? Legislature, executive, and judiciary, right? So this whole thing is basically where they are separating separating the nature of what they do. All these are coming from where crown has all the rights, but crown cannot be everywhere and crown cannot do everything. So that's why they have divided the powers of the crown into three different things here. Okay, and under the law law part they're again taking two different parts.
Hmm.
Okay, they're not talking about politics, of course. They have just confused you with this particular sentence, and they
Okay.
just then went on. This is where it starts. Federalism is where it starts. That's the main topic. Then the branch, they are going into the specific topic here. That is the section 91 and 92, where the division of power is given.
So such a
And
question, when you have written, it's just the answer. You have to comment on it. They won't
yes,
ask such a question actually. I don't think they ask that.
no, this is like this. They had asked earlier, but nowadays not so much. But sometimes what happens,
But it's good
91,
because then you're very clear about the topic. If something else
yes,
comes which incorporates this, you know how to answer it.
yeah, exactly. So that's why we have added this. So we'll go with the starting of the Canada's federalism, 1867 Act, then how the division of power happens, more of the constitutional law concepts like you already know, right? So those things. So we'll go with the more important one. Parliamentary privilege is something important. So, would you read the question?
The
One
speak
second. Sorry. Yeah.
The Speaker of Quebec's National Assembly fired three security guards for using assembly cameras to watch people in nearby hotel rooms. The security guards, however, challenged this decision as they were of the strong belief and opinion that they should not be fired. According to this, their union filed grievances, a formal complaint under a collective agreement on their behalf. This was the normal procedure for civil servants who felt they had been wrongly fired by their employer, wrongful dismissal. In this case, however, the Speaker said his decision to fire the security guards was covered by parliamentary privilege. Perfect. This is very straightforward. It's that Chagnon case that's there.
Hmm.
That's
So
the
the
most
question
relevant.
is, yeah, in this context, highlight the applicability of the concept or defense of parliamentary privilege. So this is directly connecting to that case, what happened, right?
So in that
So,
case, they say that this we will have to talk about the rule of recognition, rule of necessity, and whether
hmm,
it's actually. So first I think we'll talk about whether there's any historical precedent, and that if it's
hmm,
not there, is it directly necessary for the functioning of parliament. And I think in the
yeah.
Chagnon case, they say that labor disputes do not go to the heart of the functioning, so it's not directly necessary. And
Yeah. Here, the Supreme Court ruled that the Speaker of Quebec's National Assembly, when he cited Parliament privilege to dismiss the security guard, the court held that the dismissal was an administrative action, not a legislative necessity, and should follow the standard grievance process. So, the security guards who had a standard grievance process for wrongful dismissal, that will be going forward.
Yeah.
Okay, parliamentary privilege cannot be asked. So here basically we have given background of parliamentary privilege, what it is. We are clearly stating that when it is given, what is this called? It is an immunity granted to whom, when it is covered, when it is not covered, right? And under the constitution also, it is sort of given over there. And then the case laws where it started in Wade case, and
Yeah.
then we have the important case, the specific case, okay, and any supporting case if needed. I always give a little bit more so that there is a difference between one student's answer to another student's. So
Okay.
you can choose the main important one. Then the article. Do you have
Yeah.
this article now?
Yeah. Yeah. We do.
Okay, then you can apply this. Otherwise, if any topic, any answer you see that that article is not there, then go to your notes and see that what is the article that is applicable. Just
Yeah.
replace with that.
Yeah.
Okay, good. Let's see. By jurism. Can you read this?
Canadian courts are entitled to revisit precedents set by higher courts. Is it proper for lower courts to depart from high court precedent? B. What has made the policy towards civil law change from assimilation to adaptation harmonization?
First one
Um,
is on different topic. So here
Okay,
when
precedent, yeah. So is it proper for lower courts to depart? So I think there are just you should not, the standard is stare decisis because a lower court is bound by a higher court,
hmm,
and then I think we talk about which courts you're bound by. So you're bound by the higher court in your province and the Supreme Court. You're not
hmm,
bound by another province because that's persuasive, and also international courts are persuasive. But then there
hmm.
are exceptions where you can depart, which is if the higher court has changed made a change, and then I
The
think
law
there's
is changed. If
the
the law
law is
is changed,
changed,
yeah.
or if the higher court has reversed it. Also, there's something I may be wrong, but there's one thing which says that if it's like the law is incorrect or something like
Hmm,
that.
yeah. So in case, see what happens, sometimes the law will be held as invalid later on after
Yeah,
the
yeah,
decision was given, or the factually the matter is different. It does not
right,
mean that every time you have to go with it. If the factually the matter is different, yes, the lower court can depart from the higher court's precedent. So those are the exceptions, like exception situations. So case by case basis also they can go beyond. But in principle, if the law is, the higher court decisions are a precedent, if it qualifies as a precedent, then you have to go with that particular case.
right. The
In
second
principle, you
one,
have to go. Yeah.
I just want to confirm, I'm a little confused about the second question. Are they talking about, because so now civil law is just Quebec, right? So are they saying what has made it change from assimilation to adaptation, harmonization? Like, are they saying that they want like civil law and common law to work together, right?
Hmm.
Harmonization. But
Yes.
assimilation, like in which, when was it assimilated? Like, I don't understand.
Change from assimilation. What has made the policy towards civil law change from assimilation to adaptation? Let's see.
Because bijuralism was always that we want common law and civil law to work together.
Coexist. Yeah. So in
But
order
I
to
never
coexist together,
I never thought that it ever spoke about assimilation. Actually, it
initially
was
aimed at,
initially aimed. I didn't know. How would it assimilate? Like how would it work?
yeah, let me see. Initially aimed at assimilation, federal policy evolved to harmonization, ensuring legislative history.
Because they had always recognized Quebec as a distinct society and all. So I don't know how the assimilation would work.
Hmm. Grimaud case, do you have?
Yeah, we do. We
Okay.
do.
The shift from assimilation lifted the Canada state and
Let me
evolution
just
to
go
the
over Grimaud's case now.
hmm,
Grimaud.
jurisdiction center. But present
Grimaud talks about basically how um, they said that there's no conflict between civil law and common law, and
hmm,
it because it was in Quebec, they said that both can coexist.
hmm. Okay.
The
Let me
court
just
rejected the idea that civil law and common law tests are inherently opposed, They are complementary tools to determine the true nature of the relationship.
Hmm. Just give me a minute. I'll just clarify this.
It's okay. It's not so important. Like if you know.
This is, little bit deeper. We'll just conclude it in one paragraph so that, we have clarity.
Yeah, yeah.
So, mm, before modern bijuralism, civil law was assimilated, right? That means now federal statute used common law terms, and Quebec civil law was forced to fit common law language. Okay. And
Okay.
Supreme Court judges reasoned in common law concepts, even though from, civil law places, if it goes to Supreme Court, of course, the cases will go to Supreme Court, but the Supreme Court judges reasoned in common law concepts, and the civil law rules were misunderstood over there.
Okay.
And Quebec law treated as a local custom and
Uh-huh.
not as a full legal tradition. Civil
Right.
law gap filled using common law. This distorted Quebec doctrines. Civil law was not treated as an equal, it was treated as a variation of common law earlier. So it was
So
assimilated in that manner. And
then to rectify all that, they did that
bijuralism,
bijuralism, and then
yeah,
Quebec is a
yeah,
distinct society and all that.
yes, yes. So it is recognized as equal. It is also
Okay.
equal. Civil law concept is also equal, and the doctrines has to be recognized in the Supreme Court also. And I think I've read somewhere about the judges, the appointment of judges. A certain percentage of civil law judges also have to be there in the Supreme Court. Have you
Yeah,
read?
yeah.
Yeah,
Yes, three
yeah.
judges to be from
Yes,
Quebec.
that is also from the bijurism concept. So, in order to recognize, otherwise, what used to happen earlier, the Supreme Court judges reasoned in common law concepts only, not with the because they did not have the first-hand experience of civil law concepts. That's
Right,
all.
right.
Okay. Theories, let's skip. We'll go to the questions that we have not touched upon. How the judiciary is independent of other two branches of the government and its dimensions and its core characteristics. So basically, this is about judicial independence concept
Yeah.
where you will talk about like there are different
Those three factors,
yeah, why it
financial
has to
independence,
be.
security
Yes,
of tenure, administrative independence. Then
yes.
it should be the appearance of independence, uh,
Hmm.
and the
Why
test,
also
a
we have to
reasonable
right.
person. Yeah, why?
In order to make a decision without any pressure from other things. That's why judiciary is kept as independent, part. And judicial independence in Canada, in order to have a different structural and procedural mechanism so that they can make the decision without any pressure from the external factor.
Right, right, right.
Critically analyze the current approach to statutory interpretation that is adopted and followed by the courts in Canada. So, what is the statutory interpretation current approach?
The modern approach,
Yes.
which says that you have to follow the text, context, and purpose. But
Hmm.
then I'm I'm a little confused because this,
Hmm.
like, the text, context, and purpose is a little vague because see, the text goes back to the plain meaning rule. In
Yes.
the plain meaning rule, you're following more of the text. Then in
Hmm.
the doctrine to fidelity to legislative intent, you're giving a more purposive approach to the actual intent and the purpose. So that
Hmm.
also goes back to the purpose, like text, context, and purpose.
Yes.
So I feel like text, context, purpose, maybe they're trying to have a balanced approach between
Yes. They want to
text and
mix
purpose,
everything. Yeah. So they are saying
right?
that it is not
They don't want to give more power to the text or more power to the intent.
yes. So they want to club both of those and see in the context. Context is basically, when I say something, like I write a message, right? Or I tweet something. So that time, in what context I'm talking about, that has to be clear. Otherwise, it can be easily misunderstood, right? The words can be easily misinterpreted. So when you look at the intent, the purpose of the statute, if it is for protection of women and children, for example, the law is for protection of women and children, and there is a clause in that particular law which basically does not fit into that. If you just read the text of that particular clause, it does not protect the women or the children. Okay, so that is where you balance with that particular clause and the purpose of the act. So you contextually interpret it, and it has to come in the the conclusion of that particular interpretation has to be in line or aligned with the purpose of the statute. That is where the modern approach is making more sense.
Right.
So this is again, I think, truth and reconciliation, where they have given one particular paragraph of that particular TRC article. So you can write this whole thing, where section 35 is also added. Administrative law, judicial review, I have seen that. So anything else?
I'll go through all this. Don't know.
Yeah. Let me see if any tough question if I have. From the NCA sample paper, you have gone through the
I've gone through it. Yeah, I've gone through.
papers, right? Okay. Do you have any particular questions, like we are about to end? So, like
Yeah, no,
any.
I don't really have any particular questions. It's all pretty, for now, everything is clear. And I think it was quite helpful when you told me those marks and the words and all that. And
Mm-hmm.
also those 4 steps, the sandwich and all. I'm gonna do that. Now I
Mm-hmm.
think we should just figure out which ones I'm getting the notes so that I can then
Mm-hmm.
decide.
Yeah.
So obviously I'm
So
taking that, what is it called? That exam day
exam day
assist.
assistant. Yeah.
Then
This
the
one,
question answers, um,
all the
the
set
main
I'll
question.
give you, but the main one you can print out. Yeah.
So which is all the set has how many? I'm not sure.
10 questions is the one you will print out. Let me
And the
show.
others are which? That 10 I
Others,
know, those 10s.
yeah.
That
So
these
then
10
the
are
chapter one,
these 10 are the one which are you said
similar
what is the
to exam
UBC one?
questions.
The UBC similar to that, right?
Yeah, similar to NCA pattern.
Okay.
Then these are, basically like my way of making the questions with the help of AI, but writing the answers
That's
on
fine.
that.
Okay.
Yeah, yeah.
Then
So
this is
these are.
one.
Then
Then
we have specific to Mathur case. Then this is the sample answer for the NCA Foundation. Then we have some additional questions also should be there, because usually what happens when students are preparing, no, so they come around like 30-40 days before the
yeah, yeah.
exam date. So a lot of times they finish off all the questions that I have given. They'll be like, okay, give me
They
more
want
questions
more.
on this
Yeah.
particular topic. Huh? So
Right.
more
Right.
questions are prepared, and mock exam is there. Mock exam, I think this has the answer as well. Let me see. I'll just send you the question part so that you can answer those. And yeah, this has the answer as well. Mock exam, this one, let me see the date. Huh. This was April 2025. April, May, June, July. July they changed the syllabus. No, I'll check and I'll give you the mock exam of July.
Yeah, yeah.
Okay. I think
July
I have
20.
it in WhatsApp. Yeah. So July is because the articles are changed, no? So based on that, I had prepared a mock exam. So I'll send you that for
This
your.
exam assistance you don't have with the updated, right? You have the old one only, right?
Yeah.
Don't worry. It's
So,
okay. It's just few articles, so I'll figure it out.
oh, yeah. So, okay, I'll just stop the recording.